In trimester 1 2017, I'm offering for the first time a master's seminar course on foreign relations law. As this course is new and the term foreign relations law doesn't have any general currency, at least outside the United States, I thought it might be helpful for me to explain in this short video what foreign relations law is, why you might want to consider taking it, and what the course will involve. So firstly, what is foreign relations law? In his recent work, Foundations of Modern International Thought, the political philosopher, Professor David Armitage, comments, "There's been a fundamental assumption that there were two distinct realms called variously the international and the internal, the domestic and the foreign, or in a more legalistic idiom, the municipal and the international. That dichotomy remains perhaps the least investigated of all the fundamental divisions in our political lives. In my view, that division in our thinking has had serious practical consequences for the many urgent problems confronting us, which span the boundary between international law and national law. Take some current examples in the media. Who has the competence within the British Constitution to trigger Article 50 of the European Union Treaty, the executive or parliament? To what extent can the British government be made accountable in the courts of its own state for the actions of its officials abroad, a set of issues currently pending in the UK Supreme Court relating to the activities of the British Armed Forces in Iraq and Afghanistan and the actions of its intelligence services? So foreign relations law then concerns all those principles that govern the external exercise and effect of the public power of the state within the national legal system. You could talk about it as a kind of conflict of laws for public law, but with the salient difference that it has to engage with the way in which public international law interacts with the domestic constitution. So why might you want to consider taking this course? I suggest at least three reasons. Firstly, it's relevant. Foreign relations law tackles many issues that are highly relevant and topical, but often inadequately studied within the existing legal categories covered in the LLB degree, such as, for example, the cross-border scope of public law, international criminal judicial assistance, the cross-border regulation of the markets and the like, or the adequacy of domestic mechanisms for the review and ratification of treaties, such as the recent debate about the adoption of the TPPA here in New Zealand. Or the exercise of the war power, who gets to decide when our armed forces should be sent abroad? Or what's the scope of human rights protection from the acts of the state abroad? When ought a state to exert diplomatic protection in aid of its citizens mistreated in foreign states? When can a foreign state sue in our courts, and when can it be sued? Well, these issues come up in practice all of the time, and they're a particular issue in my consultation, the day-to-day work of legal advisors in the Ministry of Foreign Affairs, in Crown Law and in other government departments, and also in private practice. Second reason is it's academic. So what? We're a university, of course it's academic. But my point here is that a major problem that confronts lawyers in this field is the absence of an established framework for analysing the issues. I said before that this was a kind of conflict of laws for public law, but the reality is that there has been no developed field called a conflict of laws for public law. And public international law alone cannot answer the questions that confront the lawyer considering the treatment of international public issues within the national legal system. That's a mixed question of international law on the one hand and the national constitution on the other. So in writing my recent book, Foreign Relations Law, published by Cambridge University Press in 2014, I sought to address that gap within the context of Commonwealth legal systems. I want to use that work as a basis for the course, teaching it here at Victoria for the first time. The third reason is the subject is fascinating. It lies at the interface between hard law on the one hand and politics on the other, and there's new issues which simply come up all the time, so there's a great deal of scope for individual research. So what does the course involve? Well, I'm going to teach it in trimester 1 in a series of 12 two-hour blocks. and it'll be divided into two parts. In the first part, I will aim to lay out for you the structure and principles underlying the whole area, using my book as a basis, and looking at the sources of foreign relations law, the exercise of the foreign relations power and its distribution amongst the organs of government, the rights of the individual in the foreign relations law context, and the position of the foreign state. And then in the second half of the course, we'll move to the presentation of your ideas, individual student research on hot topics within the field. So throughout, the course will involve active learning through critical engagement of students in discussion, invited participation of some guest speakers working in the field, and a chance to develop and hone your own research and writing skills. If this sounds interesting, do consider enrolling in LAWS547, Foreign Relations Law, Trimester 1, 2017. If you'd like to discuss any aspect of the course with me in advance, please don't hesitate to email me and we can get together to meet. Thanks very much.